Today's story is about a man who bought beachfront property, only to be told later that he could not build anything on it. This is the story of Lucas versus South Carolina Coastal Council. The year was 1986. David Lucas bought 2 residential lots on a South Carolina beach for nearly $1 million. His plan was simple: build homes on the land. At the time he purchased the property, building was allowed. But soon after, South Carolina passed a new law called the Beachfront Management Act. The law was designed to protect the coastline from erosion and environmental damage. Under the new rules, Lucas was suddenly prohibited from building permanent homes on his lots. To Lucas, the land had become almost worthless. Welcome to Once Upon a Case, because the law isn't just for lawyers, it's for everyone. He argued that the government had effectively taken his property without paying him compensation. South Carolina disagreed. The state argued that it was simply regulating land use for the public good. After all, governments regularly pass zoning and environment laws. The case eventually reached the Supreme Court of the United States in 1992. The big constitutional question was this: when does government regulations go so far that it becomes a taking under the Fifth Amendment? In a major decision, the Supreme Court ruled in favor of Lucas. Justice Antonin Scalia wrote that when a regulation deprived land of all economically beneficial use, the government generally must pay compensation. In other words, if regulations make property essentially useless, it may count as a taking, just like physically seizing the land. The ruling became one of the most important property rights decisions in modern American law. It helped define the limits of government power over private property and is still studied in constitutional and property law classes today. And that's the story of Lucas versus South Carolina Coastal Council. Thank you for watching. If you enjoy this story, follow along for more. See you on the next episode.